Let me begin by congratulating the ICLR on its 150th birthday and celebrating its contribution to the rule of law. It is appropriate that the Council is sharing its significant anniversary with Magna Carta's significant anniversary. Whatever view one takes of it in the 13th century, the Great Charter is currently seen across the world as being the most significant landmark in the history of the rule of law. And for many centuries, law reporting has played a vital part in establishing and maintaining the rule of law. That's particularly true in common law jurisdictions such as ours, where judicial decisions are part of the law of the land and play an important part in developing the law. And it's an essential ingredient of the rule of law that the law is publicly available and as easy to understand as possible. Law reporters are the unsung heroes and heroines of the common law. The role of judges and legal practitioners in developing the law has been taken for granted for centuries. And while, at least in this country, the role of legal academics has only become fully recognised relatively recently, the contribution of the law reporters is not always properly appreciated. Selecting important cases, preparing a headnote, ensuring judgments are accurate, identifying the facts, the history and the cases cited, and summarising the arguments precisely all require expertise, intelligence, care and effort. And the moment one stops to think about it, one realises how great an influence law reporting must have on the development of the law. In the past, unless they were reported, judgments were hard to know about and even harder to find. So the selection and other tasks carried out by the law reporters plainly played a vital part in the perception and development of the law. Even now, with the electronic reproduction and consequent easy and immediate access to so many judicial decisions, law reporting still plays a vital role. The very fact that so many cases are available electronically means that selecting and reporting the really important decisions is as vital as it ever was, as are the other law reporting functions. In other words, in the legal world, as in other fields, a significant present-day problem is information overload, whereas the corresponding problem for most of the Council's 150 years of existence has been information scarcity. As has been explained earlier, the ICLR was conceived by a group of lawyers, most notably Sir Nathaniel Lindley, who wrote a paper in 1863 explaining the need for a professional body of law reporters. And as has been said, very necessary it was. The law report had been a hit-and-miss affair up till then. The reporters included Espinasse, who, according to Chief Baron Pollock, heard one half of the case and reported the other. They included Keble, whose reports Chief Justice Willis said seldom enlightened anything. Sidafin, whose reports, according to Mr. Justice Dolben, were fit to be burnt. Taunton, who was described by Baron Park as an apocryphal authority. And Barnetson, who Lord Lyndhurst, Lord Chancellor, said was accustomed to sleep over his notebooks, and the wags in the rear took the opportunity of scribbling nonsense in it. By contrast, since 1865, as a result of the founding of the ICLR, we in this country have been very fortunate to have the benefit of outstanding law reporting. It was Lord Bingham, no less, who said that the best law reporting was a work of scholarship, and he went on to refer to what he called the amazingly high standards of the accuracy of the weekly and full law reports. Just as the fact that we take the rule of law for granted in the United Kingdom is a compliment to our society, so is the fact that we take first-class law reporting for granted a compliment to the law reporters. And I would like to pay my own personal tribute to the individual law reporters who have covered my judgments throughout my judicial career. It would probably be invidious to name them today, but I have fond and grateful memories of the discussions we have had, gossip as well as law, I must admit, and the contributions they have made, and of course it still continues. In his 1863 paper, Lindley identified the 4 criteria for reporting a case, and you heard what they were earlier. Each of the 15 decisions which you have on your list and which have been mentioned already in general passes these requirements with flying colours. But if they had not been reported, we could not be confident that all of them would have come to the attention of the legal world and would enjoy the significance which they have achieved. It's an impressive list, and you have it before you. I cannot resist beginning with some sort of statistical breakdown. We have one purely criminal case, one criminal case with family connections, one family case with criminal connections, 7 private law cases, and 5 public law cases. Of the 7 private law cases, 3 are landmark cases in tort, 2 in negligence and 1 in nuisance, and 2 are important contract cases, one concerning the nature of a contract and the other contractual interpretation. Of the remaining 2 private law cases, one decided a fundamental point of company law and the other is a famous case on estoppel. 2 of the 7 started in the Chancery Division and the other 5 in the Queen's Bench Division. The 5 public law cases are not just significant legally, they are of great constitutional relevance in that they raise important issues about the relationship between the judiciary and the other 2 branches of government. The perception that the proportion of public law cases has increased sharply over the past 150 years, and particularly in the past 40 years, is supported by the fact that all 4 of the earliest 4 cases were private law cases. However, what is perhaps more surprising is that 3 of the public law cases were decided between 1940 and 1970, and only 2 in the 45 years thereafter. Only one of the 15 cases, Donahue, is Scottish, and none is Northern Irish. But as the population of Scotland and Northern Ireland are far less than that of England and Wales, and no Scots or Northern Irish cases are reported by the ICLR unless they get to the House of Lords, that is scarcely surprising. Despite nearly 15 years since the Human Rights Act came into force, there is only one human rights case, and the Home Secretary. And despite the UK having been in the EU for 40 years, there is no EU law case. But that may be because difficult cases on EU law must be referred to Luxembourg. Of the 15 cases, 11 were decisions of the House of Lords, 3 the Court of Appeal, and 1 the High Court. That seems reasonably in line with what one would expect. The top court should get the lion's share of important cases, but there are always some significant, and indeed some very significant cases, which go no further than the Court of Appeal or the High Court even. There are no Supreme Court cases, despite our nearly 6 years of existence. I suppose that we can console ourselves with the thought that the decisions take time to sink in, or maybe it's because the most effective decisions, which are those which appear most obviously right and therefore make no mark. As for the judges, it's fitting that Lord Justice Lindley gets into the list through his judgment in Carlisle, given that he was the leading figure who founded the ICLR. Not unpredictably, the one High Court judge in the roll of honour is Mr. Justice Denning, which may seem to confirm his star status. But the star dims somewhat once one sees that there is no other decision to which he was a party. Lord Reid and Lord Wilberforce, 2 other giants, only feature in one case, as does a more recent great giant, Lord Bingham. Even more remarkably, Lord Diplock, so dominant, many may say, so overbearing, others may say, for 17 years, does not figure at all. A number of law lords get 2 credits, and I'm not going to list them all, but there are 2 law lords who get 3 credits. One, of course, is the great Lord Atkin, Donahue and Stevenson, Liversidge and Wilmington, where he was a silent performer. And the other one with 3 is Lord Walker, 2 in the House of Lords, A in the Home Secretary in Chartbrook, and the other in the Court of Appeal is Lord Justice Robert Walker in conjoined twins. With that statistical or bogus statistical analysis, I propose first to deal with the private law cases, then with the criminal and family cases, and finally with the public law cases. The private law cases serve to establish the creativity, the flexibility, and the vigour of the common law by demonstrating how it was developed by judges to regulate relationships in the private sphere in a way which reflects the expectations and standards of society. The first case in time is Rylands and Fletcher, which of course famously decided that where a person keeps something on his land which is likely to do damage if it escapes, he's liable for any damage which is the natural consequence of its escape. In an article in the Law Quarterly Review, written shortly after it was decided, Sir Frederick Pollock described the rule in Rylands and Fletcher as consolidating the judgment of fact into an unbending rule of law. As that description shows, Rylands was treated as creating a new tort, and as the supposed new tort was given the name of the case which created it, it's perhaps unsurprising that the decision was well known to law students and practitioners alike. One frequently saw pleadings when I was at the bar alleging that the defendant was liable in negligence and oblique or nuisance and oblique or under the rule in Rylands and Fletcher. But almost since it was decided, and particularly over the past 30 years, the significance of Rylands has been fading. In a number of early 19th and 20th century decisions, it was a number of late 19th and early 20th century decisions, it was held to be subject to what the leading textbook on tort, Clark and Linsell, calls a large number of exceptions. In 1985, Rylands was held authoritatively never to have been part of the law of Scotland by the House of Lords in a speech when the supposed rule in Rylands and Fletcher was described as a heresy that ought to be extirpated. 20 years ago, the High Court of Australia held that the claim in Rylands was properly classified as a claim in negligence. In England and Wales, the effect of two decisions of the Law Lords appears to be that Rylands did not give rise to a new tort or claim in negligence, but was simply an extension of the law of nuisance in cases of isolated escape. In these circumstances, some may think that Rylands' appearance in the list is attributable to its past familiarity rather than its present importance. By contrast, no part of the reasoning in the next case, Carlisle, has been doubted in any subsequent case. It is probably the best-known decision of a common law court on the law of contract. That is partly, I think, due to the name of the case, partly due to the facts which gave rise to it, and above all, because the judgments of the Court of Appeal support a number of basic propositions of the law of contract, and it's often the first case that any law student is taught. At the height of the 1891 flu epidemic, Frederick Rowe, trading as the Carbolic Smokeball Company, marketed the eponymous smokeball for sale at 5 shillings, 25p to those of you who don't remember, on the basis that he would pay £100 reward to any buyer who contracted flu when regularly using it. The contraption apparently consisted of a hollow rubber ball containing carbolic acid, which was inhaled through a tube attached to the ball. Louisa Carlisle bought the smoke ball and caught flu, and no doubt encouraged by her husband, who was a solicitor, she claimed the £100. The Court of Appeal upheld the claim, holding that all the essentials ingredients of a contract were present. There was an offer, which was not too vague. There was acceptance by purchasing the smoke ball, even though it wasn't verbally communicated as an acceptance. There was consideration, which consisted apparently of the inconvenience of using the smoke ball and also of increasing the company's sales. And there was an intention to create legal relations. Lord Justice Bowen described that intention as being based on the proposition that the offer was not mere puff. That was not, I think, to be intended to be a jokey pun about the smoke ball. The Court of Appeal's reasoning was recognised from the start by an early edition of the Law Quarterly Review as being of general interest and importance to students of the law of contract. The case is also of some interest to medical historians, as it demonstrates the growing popularity of inhalation as a treatment, according to a book on asthma. It might also be of some interest to the marketing world, as not a whit deterred, Mr. Rowe proceeded to advertise his product after the Court of Appeal decision, relying not only on the judgment to show that he was really putting his money where his mouth was, but actually increasing the reward to £200. Mr. Rowe was not only clever at marketing. Having originally sold the smoke ball on his own account, albeit in the name of an unlimited company, the marketing after the decision of the Court of Appeal was by a new company that he had formed, the Carbolic Smokeball Company Limited. He was 3 years ahead of the law, because in the 1896 decision in Salomon, the House of Lords authoritatively decided, of course, that a limited company had a separate legal personality from its shareholders or subscribers, who could not therefore be rendered liable for its debts or liabilities. Contrary to the view of the Court of Appeal, they said that there was nothing wrong in an individual incorporating his business simply to take advantage of limited liability. Just as well for Mr. Carlyle, because his company went bust. The Law Quarterly Review at the time suggested, slightly oddly, that there was nothing startling in the decision of the House of Lords in Salomon, even though they had reversed the Court of Appeal, including Lord Justice Lindley, and the first instance judge. The LQR also rather oddly suggested that the decision would have been, quote, impossible 30 or even 20 years ago, even though the reasoning rested on the wording of the Companies Act, which had been passed 35 years earlier. The decision in Salomon is important, of course, and like Carlyle, it has stood the test of time. There have, however, been subsequent cases where the courts have been prepared to pierce the veil of incorporation, an expression which means disregarding the separate personality of the company. Those cases were recently considered in two decisions of the Supreme Court, in which the judgments reveal a degree of variation as to when the court should properly pierce the corporate veil, as opposed to finding liability on more orthodox grounds against a shareholder or subscriber. But the clear message from those cases is that Salomon is still very much good law, and it will require an exceptional case before the court would even consider piercing the corporate veil. Carlyle reminded lawyers of the need for consideration in order to found a contract. It was the absence of consideration which led to perhaps the most famous obiter passage in any judgment in the past 150 years. In January 1940, the owners of what was to become probably the most famous block of flats in English law, High Trees House, agreed to accept rent at half the contractual rate from a tenant because the war had reduced occupancy rates substantially. When, after the war, the block became fully occupied again, the landlord demanded rent at the full rate. And in his 1946 High Trees decision, Mr. Justice Denning agreed that he should have it. His historic observations were devoted to explaining why the landlord was not entitled to recover the rent at the full rate during wartime if the landlord had asked for it, which he hadn't. There is no enforceable contract in English law where a creditor agrees to accept a lower sum than that to which he is entitled to in law. That is because of the absence of consideration. However, relying on some previous relatively overlooked authorities, Mr. Justice Denning said that as the landlord had made a promise to accept rent at half the contractual rate during wartime, and the tenant had reasonably and foreseeably acted on it by not vacating the flat, the landlord would have been estopped from claiming the full rent, at least until he gave reasonable notice of intention to resile from his promise. High Trees was greeted at the time by the Law Quarterly Review as demonstrating that the common law is still capable of development apart from changes made by legislation. However, a much less sanguine view of High Trees was taken 6 months later when a note in the Law Quarterly Review said rather sniffily that most of the judgment of Mr. Justice Denning, and certainly all that is of any real interest in it, was obiter, so the case was scarcely reportable, much less epoch-making. But 10 pages later, in the same volume of the LQR, there was a more enthusiastic note describing High Trees as important, not only within its present particular context, but also for its potentialities in other branches of the law. The past 70 years have, I think, borne out the views of the more enthusiastic commentator. Thanks to High Trees, promissory estoppel, indeed various other types of estoppel, have been much more frequently raised in legal argument, discussed and developed in judgments, and been the basis of actual judicial decisions. To say that Lord Denning, or Mr. Justice Denning, invented promissory estoppel is to put it a little too high. But as Mr. Justice Denning, he rediscovered it and publicised it in High Trees, and as Lord Justice Denning, 10 years later, he developed it in Coombe and Coombe. As High Trees are to estoppel, and as a smoke ball is to contract, so is a snail in a ginger beer bottle to negligence. I refer, of course, to the famous claim brought by Mrs. Donahue, who claimed to have suffered from gastroenteritis as a result of drinking ginger beer, and contending that this was caused by the manufacturer, Mr. Stevenson, negligently letting a snail get into the ginger beer, where it had partially decomposed by the time that she drank the ginger beer. On the assumption that the facts were as alleged, the Inner House rejected the claim on the ground that product manufacturers owed consumers a duty of care only if they were in a contractual relationship. In doing so, they followed an earlier decision involving a different ginger beer manufacturer, AG Bar & Co Limited, and a different partially decomposed animal, a mouse. Makes one wonder about ginger beer, at least in the 1930s. By a bare majority of 3-2, the House of Lords took a different view. Lord Atkin, of course, gave the leading judgment, saying that he did not think a more important problem has occupied your lordships in your judicial capacity, and famously going on to state that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour, and then, with a deft change of pronouns, define neighbours as persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. Accordingly, he said, manufacturers, what he called articles of common household use, owed a duty of care to consumers. Lords Thankerton and Macmillan agreed, although they did not go so far as Lord Atkin in identifying any general principle. Lords Buckmaster and Tomlin disagreed, essentially on the ground familiar to advocates and judges, that the majority view would involve an unjustifiably radical change in the law and would risk opening the floodgates to a multitude of claims. Incidentally, it's often said that there was a subsequent hearing at which it was held that there had in fact been no snail in the ginger beer bottle. But the truth is that the claim was settled by Mrs. Donahue with Mr. Stevenson's executors. Unsurprisingly, Donahue was greeted as a significant case at the time. The Law Quarterly Review said the House of Lords itself has proclaimed the importance of the decision. The editors went on to thank the Scots Lords of Appeal for overriding the scruples of English colleagues who could not emancipate themselves from the pressure of a supposed current of authority in English courts. The editor also suggested that while Lord Buckmaster and Lord Tomlin are the last men, the dissenters, are the last men one would have suspected of timidity, parts of their opinions read as if they had forgotten that they were judging in a court of last resort. I think the full importance of Lord Atkin's speech only became clear over 30 years later as a result of two further landmark decisions of the House of Lords. First, in 1965, the duty of care described by Lord Atkin was extended to apply in negligent misstatements in Headley Burn, a case whose omission from the 15 cases I also remarked on. Secondly, 5 years later, in Home Office and Dorset Yacht, Lord Reid described Donahue as a milestone and said that Lord Atkin's speech should be regarded as a statement of principle which ought to apply unless there is some justification for its exclusion. As often happens, the pendulum then swung too far. Having been too restrictive before Donahue, the scope of duty of care not merely developed in the two cases I've just described, but became too expansive. This was, I think, principally as a result of the House of Lords' 1977 decision in Annes and Merton, whose effect was to create a risk of what a great US judge, Justice Cardozo, called a risk of liability in an indeterminate amount from an indeterminate time to an indeterminate class. Indeed, that quotation is to be found in the leading speech of Lord Bridge in the 1990 decision of Caparo, the next case in our 15 which is to be considered, which represents at the moment the end point of the chain of cases which started with Donahue. The House of Lords in Caparo identified a three-part test which has to be satisfied if a negligence claim is to succeed. Damage must be reasonably foreseeable as a result of the defendant's conduct. The parties must be in a relationship of proximity, or, Lord Atkin's word, neighbourhood. And 3, it must be fair, just and reasonable to impose liability on the defendant. As a result, the House of Lords in Camparo reversed the Court of Appeal. The House held that accountants did not owe a duty of care to the actual or potential shareholders individually when carrying out a statutory audit of the company's accounts. The purpose of the audit was to enable the shareholders as a class to decide how to vote at general meetings, and it was to them that the duty was owed. The last of the 7 private law cases is Chartbrook, a case dealing with the meaning of commercial contracts, where the leading speech was given by Lord Hoffman, whose contributions in many fields of law, including contract law, was outstanding. The decision has 3 strands, and each strand has had its critics. The first strand was confirmation of a principle supported by what Lord Hoffman called a long and consistent line of authority, the binding force of which has frequently been acknowledged, namely that evidence of pre-contractual negotiations cannot be taken into account by a court when construing or interpreting a contract. There is obvious force in the counter-argument that there is no logical reason why evidence of negotiations should be inadmissible. However, as always, the common law, being practical, considers that if evidence of negotiations could be admitted, lawyers would be far more tentative and uncertain in their advice, legal proceedings would often take far longer and cost far more, and many experienced lawyers suspect that the resultant evidence would rarely affect the outcome. The second strand of Chartbrook was that when interpreting a contract, the court can correct a mistake without having to resort to the remedy of rectification, providing it's clear from the document and the admissible context that there was a mistake and what the correction ought to be. Lord Hoffman said there is not a limit to the amount of red ink or verbal correction which the court is allowed. In a characteristically trenchant article in the Cambridge Law Journal, Sir Richard Buxton suggested that by going further than correcting clerical errors, Lord Hoffman's approach was inconsistent with both legal principle and prior authorities, and that he had reduced the difference between construction and rectification almost to vanishing point. In a recent case, which involved a husband and wife who had inadvertently executed each other's wills, Marley and Rawlins, the Supreme Court considered this debate, but left it open for another day. The third strand of the decision in Chartbrook was that the requirement for rectification, that the parties had a common understanding which was different from that recorded in the contract, must be objectively assessed, and that it did not matter that subjectively the parties had not reached accord. This was criticised in articles in the LQR, and a decision of the Court of Appeal to which I was party struggled with the reasoning in Chartbrook on this point and raised the question whether it was correct. Further articles ensued. In his article, which I've referred to, Sir Richard Buxton thought that the objective test was another way in which the principle of rectification and construction had been conflated. This view is reinforced by the editors of Chitty, who say that Lord Hoffman's objective approach has to be treated with caution. I turn to criminal and family law cases. There are 3 cases which highlight the common law at work in different ways. The first demonstrates the concern of the common law that those accused of crimes are given a fair trial. The second shows that the concern of the common law to protect victims of wrongdoing, the other side of the coin in a way. And in the third case, one sees the common law interacting with acute moral issues. In the first case, Wilmington, the defendant had visited his estranged wife, carrying a sawn-off shotgun, and had shot her dead. At his trial for murder, the defence was that he had taken the gun with the intention of shooting himself, or threatening to shoot himself, if his wife did not take him back, but the gun had gone off by accident. The judge directed the jury that the case against Wilmington was so strong that the burden of proof was on him to show that the shooting was accidental. The jury convicted him and he was sentenced to death. The Court of Appeal upheld the direction, which was supported by well-established, long-standing precedent. In its 1935 decision, the House of Lords unanimously thought otherwise. Viscount Sankey, the Lord Chancellor, gave the only reasoned speech. It contains the famous statements that, subject to specific exceptions, throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt, and the principle that the prosecution must prove the guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained. That is now taken for granted, and it's relevant to bear in mind how things have changed since 1935, in the sense that we would have thought a decision of the Court of Appeal, such as was reached in Wilmington, would be very surprising. The Modern Law Review greeted the great case of Wilmington as establishing on a firm foundation the cardinal principle that every element of a criminal offence must be proved beyond reasonable doubt by the prosecution. The next case I deal with, which is another criminal case, got more general publicity, but in the end caused little controversy. In R&R, the House of Lords reversed the common law rule, which went back to time immemorial, that a man who forced himself on his wife could not be guilty of rape. The House of Lords said a man who forced himself on his wife could be guilty of rape. In taking that course in 1991, the Law Lords ensured that the UK joined a growing band of countries which criminalised marital rape. The courts of France and Spain took the same step in the early 1990s, and Germany did so in 1997. The Italian courts were ahead of them, criminalising marital rape in 1976. While it's often difficult to decide whether, as in that case they did, to sacrifice certainty for progress, many people may think that the decision in R&R, when reached in 1991, was relatively easy. It's particularly easy in a country such as this with parliamentary supremacy. The courts can change the law, securing the knowledge that the legislature can reverse or fine-tune the change if it wishes. The decision also reminds us how perceptions change over time, and what appeared self-evidently right 300 years ago can seem to us today to be wholly unacceptable. If R&R was a case which involved criminal and family law aspects, so did the next case, conjoined twins. Although law overlaps with religion and morality, it is very rare indeed for judges to be faced with a decision which throws up such a fundamental and controversial moral and religious issue. Two girls, Jodie and Mary, were born joined at the hip. If they were surgically separated, Mary would die at once, but Jodie would have a 94% chance of survival. If they were not separated, they would both almost certainly die within 6 months. The question was whether, despite their parents wishing nature to take its course, the court could or should authorise the surgery, even though it would result in Mary's death, and thus might well amount to murder. To this very difficult question, the Court of Appeal said yes. All three members of the court, led by Lord Justice Henry Brooke, who I'm delighted to see here this evening, invoked the famous decision, which is not in the list of 15, Dudley and Stevens, the famous cannibalism after shipwreck murder case, and considered that, bearing in mind that the purpose of the operation was to save a life and not to cause a death, the doctrine of necessity, the defence of necessity to what would otherwise be a murder, could be relied on. Some of the judgments included other reasons, but that was a thread running through all three judgments. The parents' concerns and interests and desires had to be taken into account, but in the end, the court, as always, was concerned with protecting the life of children. The operation was performed, and as predicted, Mary died immediately, but Jodie did survive. Bearing in mind the issue thrown up by this case, it has unsurprisingly been the subject of many articles, some strongly critical and some strongly supportive. When judges have to go into territory which is so fraught in moral and religious terms, it can be an uncomfortable experience. The public law cases now. They all raise issues, as I've said, of constitutional importance. 4 of them are directly concerned with the jurisdiction of the courts to inquire into the lawfulness of another arm of government. And the 4 cases shine an interesting light on the development of law in this area over the past 75 years. The 5th case, Pepper, was concerned with a slightly different type of issue, and I shall take it first. In Pepper, decided in 1992, for reasons given by Lord Brown-Wilkinson, the House of Lords decided to relax what he called the exclusionary rule. That was what he, quotes, described as the historic rule that the courts may not look at the parliamentary history of legislation or at Hansard for the purpose of construing such legislation. This raised a constitutional issue, namely whether such a relaxation would infringe parliamentary privilege, and what was ultimately a practical issue, namely whether it was desirable to relax the exclusionary rule. The practical argument for the exclusionary rule had been well expressed by Lord Reid in 1967. He said that, and I quote, "it would add greatly to the time and expense involved in preparing cases," and I would add to this, advising clients, involving the construction of a statute, if counsel were expected to read all the debates in Hansard. And he said, in a very large proportion of cases, such a search would throw no light on the question. Nonetheless, the House in Pepper relaxed the rule where the legislative words were ambiguous, obscure, or led to an absurdity, provided that what was said in Parliament clearly discloses the mischief aimed at. Although not mutually inconsistent, it seems to me that the refusal of the House of Lords in Chartbrook to reverse what Lord Hoffman called the long and consistent line of authority excluding pre-contractual negotiations when interpreting a contract suggests a rather different cast of mind from the earlier preparedness of the House in Pepper to relax what they called the historic exclusionary rule. Unsurprisingly, the point did not escape Lord Hoffman, who said in Chartbrook that the House's experience in the analogous case of resort to statements in Hansard under the rule in Pepper suggests that such evidence will be produced in any case in which there is the remotest chance that it may be accepted, and even those cases will only be the tip of a mountain of discarded but expensive investigation. And one can search the law reports since Pepper to find many, if any, cases where this expensive and time-consuming exercise, whether before court or after court or in court, has had any effect. The constitutional objection in Pepper and Hart to the relaxation of the rule was based on Article 9 of the Bill of Rights. This was described by Lord Brown-Wilkinson as being a provision of the highest importance. It provides, of course, that the freedom of speech and debates or proceedings in Parliament should not be impeached or questioned in any court or place out of Parliament. The House of Lords thought that there was nothing in that point so far as Pepper was concerned, and when one bears in mind the words impeached or questioned, that would seem to be right. However, in a more recent case, the Supreme Court did rely on Article 9 when expressing concern at the notion that as the result of the jurisprudence of the Court of Justice in Luxembourg, UK courts might be expected to assess the quality of the debate in Parliament when determining the lawfulness of environmental legislation. We left open the important constitutional question whether the European Communities Act 1972 overrode Article 9 of the Bill of Rights because it had not been fully argued and it was not necessary to decide it. But that is another point which awaits a decision. So long as we stay within the European Union, it will no doubt come up at some point. I now turn to the 4 cases which provide a fascinating vignette as to how the law of judicial review, in its widest sense, has developed over the second half of the ICLR's life. The 1941 case, which has already been referred to, Liversidge, concerned Regulation 18B of the Defence General Regulations. That regulation empowered the Home Secretary to detain anyone whom he had reasonable cause to believe had hostile origins or associations. In May 1940, the Home Secretary, Sir John Anderson, decided to exercise his power against somebody called Jack Pertzweig, who used the alias of Robert Liversidge. The detention order stated that Sir John had reasonable cause to believe that Mr. Liversidge was a person of hostile associations, without stating what associations and why he had that belief. Nothing further was adduced by way of evidence as to how or why he had that belief. The majority of the House of Lords famously held that it was enough that the Home Secretary stated that he had the requisite reasonable belief and that the court could not inquire into the matter further. They accepted that this might not be the natural meaning of the regulation, but they considered that such an interpretation reflected the will of Parliament. Lord Atkin disagreed. He considered that by laying down a requirement of, quote, reasonable cause, unquote, the legislation had imposed an objective test for the exercise of an executive power which could be reviewed by the court. His speech is not just notable for its conclusion, proclaiming the rule of law at a time when this country was fighting for its life, but also for its language. He viewed with apprehension the fact that his colleagues, when face to face with claims involving the liberty of the subject, show themselves, as was quoted earlier, more executive-minded than the executive. The government's arguments, which had been accepted by his colleagues, he described as might have been addressed acceptably to the Court of King's Bench at the time of Charles I. And he suggested, famously, that there was only one authority which might justify the Home Secretary's interpretation, which had been accepted by his colleagues, namely, and he quoted, "When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less." Lewis Carroll. The Lord Chancellor, Viscount Simon, tried in vain to persuade Lord Atkin to tone it down. It's said that Lord Atkin's judicial colleagues thereafter never had lunch with him. Perhaps that was a blessing, I don't know them. Unsurprisingly, Liversidge was much discussed at the time. The Law Quarterly Review published a number of pieces agreeing with the majority. Sir William Holdsworth, no less, thought that the majority were clearly right, because the issue was not justiciable, as it was not within the court's legal competence, it was, as he described it, an administrative or political issue, and therefore nothing the court could decide on. Professor Goodhart agreed. Indeed, he went further. He suggested that Lord Atkin's statement about the majority being more executive-minded than the executive might amount to contempt of court, as it suggested that his four colleagues had, and Lord Goodhart put it, consciously or unconsciously, been influenced by their prejudices or political inclinations in reaching their conclusions. An article in the contemporary volume of the Modern Law Review took a rather different approach, suggesting that the limited check which Lord Atkin's interpretation involves would impose upon the executive a reassertion of a principle for which a number of Englishmen in recent years have rather strangely lost enthusiasm. A postscript to the Modern Law Review article revealed that Mr. Liversidge, or Mr. Pertzweig, had been released in July 1943. Lord Atkin's view has, of course, triumphed in the end. The decision of the majority was described as very peculiar by Lord Reid in 1964, and in 1979, Lord Diplock, edging his way into this talk, said in terms that the time had come for the law lords to acknowledge that the majority were expediently and at the time perhaps excusably wrong, and the dissenting speech of Lord Atkin was right. Although it was wrongly decided, and therefore not even an authority, let alone an important authority, Liversidge is rightly included in the list. Lord Atkin's speech is up there with Lord Camden's judgment in Entick and Carrington, to remind us all of the importance of the rule of law, even in difficult times, perhaps one might say particularly in difficult times. And the wrongness of four eminent jurists, Viscount Maugham, Lord Macmillan, Lord Wright and Lord Romer, remind judges not to forget the rule of law in times of emergency. Before leaving Liversidge, I leave the last words to Lord Atkin. In this country, amid the clash of arms, the laws are not silent, They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty, for which on recent authority we are now fighting, that the judges are no respecters of persons and stand between the subject and any encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. The next case I want to deal with in time is Wednesbury, which of course famously gave its name to a legal standard, Wednesbury unreasonableness. Lord Green laid down the famous 3 grounds on which a court could legitimately interfere with the decision of the executive, in that case a local authority. The authority took into account matters which they ought not to take into account, the authority neglected to take into account matters which they ought to take into account, and the decision was one which was so unreasonable that no reasonable authority could have ever come to it. These 3 grounds, sometimes with refinements, have been very frequently trotted out in public and relied on in public law judgments, arguments, textbooks, and articles. Somewhat extraordinarily to modern thinking, there is no mention of Wednesbury in the contemporary editions of the Law Quarterly Review or the Cambridge Law Journal. However, in an article in the Modern Law Review entitled The Limits of Judicial Review, S.A. de Smith, a well-known constitutional and administrative lawyer, of course, described the judgment as a good example of the general trend of cases dealing with discretionary powers, which showed, he said, the courts show a marked disinclination to interfere with decisions of elected local authorities. The article went on to refer to the Court of Appeal decision a year earlier in Robinson, where the judgment was also given by Lord Green. In that case, Lord Green, with the agreement of his colleagues, held that when deciding whether to make a slum clearance order, a minister was, and I quote, at liberty to base his opinion on whatever material he thinks fit. Shades of the majority view in Liversidge. 70 years later, while we are still purporting to apply the tests laid down by Lord Green in Wednesbury, I have little doubt that he would be astonished by how much more ready judges are to interfere in administrative decisions than they were in his time. Indeed, it may be that Wednesbury is in danger of becoming history if, as some argue and some predict, Wednesbury unreasonableness is displaced by proportionality. One effect of the Human Rights Act was to import, of course, into the UK law the more structured proportionality test when considering the lawfulness of government decisions which restrict human rights. As was recently said in the Kennedy case in the Supreme Court, both reasonableness review, Wednesbury, and proportionality, human rights, involve considerations of weight and balance with the intensity of the scrutiny and the weight to be given to any primary decision-maker's view, depending on the context. However, the court went on, the advantage of the terminology of proportionality is that it introduces an element of structure into the exercise by directing attention to factors such as suitability or appropriateness, necessity and the imbalance of benefits and disadvantages. The fact that judges were moving away from the rather deferential or emasculated attitude to judicial review of the 1940s became apparent with the next decision, a decision of the House of Lords in 1968, and Robinson, the slum clearance case. The decision in question was, of course, Annie's Minnick. The Foreign Compensation Act provided for a commission which would decide whether persons whose foreign property had been confiscated should be entitled to compensation. The Act specifically provided that any decision by the Commission to accept or reject a claim could not be challenged in court. The House of Lords nonetheless held that they could quash the Commission's refusal to accept the appellant's claim on the ground that in making its decision, the Commission had made an error of law which went to its jurisdiction, and therefore a court could, indeed should, interfere. In reaching the conclusion, the House made it clear that the Commission could have made errors of law going to jurisdiction in a number of ways, for instance by acting contrary to natural justice, by misconstruing the statutory provision from which it derived jurisdiction, or by taking into account irrelevant matters and vice versa. In modern terms, perhaps the decision could be said to exemplify the principle of legality which was explained by Lord Hoffman in these terms: while Parliament can legislate contrary to fundamental principles, it must squarely confront what it is doing and accept the political cost. So that, he said, fundamental rights cannot be overridden by general or ambiguous words, as there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In reaching the decision in Annis Minnick, the House of Lords reversed the Court of Appeal, where the leading judgment was given by Lord Justice Diplock, the nearest he gets into the inclusion of the roll of honour. He began his judgment by describing it as being very long and very tedious, and we can now add very wrong. The importance of the House of Lords in Annis Minnick was appreciated at the time. It was described by the LQR as a dramatic climax to 5 years litigation over a matter which an Act of Parliament expressly forbids to be questioned in any court of law. The writer considered that it was bound to rank as a major contribution to the series of cases which have invigorated administrative law in the last few years. In the MLR, it was decided that the effect of Annis Minnick was that any error of law could be reckoned as jurisdictional, and that this was actually required by principle, as otherwise bodies whose powers are defined by law are allowed to break the law and yet remain within their jurisdiction. In the 35 years following Annis Minnick, domestic judicial review really grew up and achieved adulthood and maturity. Also in those 35 years, the Human Rights Act came into force. The 2004 case of A.M. the Home Secretary was described in the LQR as the first significant judicial decision under the Human Rights Act to executive and legislative action. The first significant judicial challenge under the Human Rights Act to executive and legislative action to circumvent convention rights. A panel of 9 law lords, led by the great Lord Bingham, decided, 1, that the Home Secretary was entitled to conclude that the threat from Al-Qaeda following 9/11 constituted a public emergency threatening the life of the nation, which justified derogating from the right to liberty under the Human Rights Convention. However, they also decided that a statutory provision in the Anti-Terrorism, Crime and Security Act, which entitled the Home Secretary to detain any foreign national whose presence in the UK he believed to be a threat to national security and could not be deported, was inconsistent with the Convention, as it was both disproportionate and discriminatory as a response to the emergency. Disproportionate because it was unacceptably draconian, and discriminatory because it only applied to non-nationals. Prior to the Human Rights Act, it would have been unprecedented, indeed inconceivable, for a court to adjudicate on a government decision made in good faith on grounds of national security and holding a provision in primary legislation unlawful, or to consider the lawfulness of any policy by reference to proportionality rather than the less demanding and less structured requirements of Wensbury unreasonable. Lord Bingham famously said that while judges are not elected or answerable to Parliament, and Parliament, the executive and the courts have different functions, the function of independent judges charged to interpret and apply the law is universally recognised as a cardinal feature of the modern democratic state, a cornerstone of the rule of law itself. This decision demonstrates and vindicates the importance of judges, and therefore it must be added legal professionals, legal academics and law reporters, to the rule of law. The steadfast judicial adherence to the rule of law in A.M. the Home Secretary during the so-called War on Terror provides a striking contrast with the more deferential judicial passivity in Liversidge during World War II. And to those who say that judges should not overrule Parliament, there is an easy answer. Our powers our powers in relation to human rights were conferred by Parliament itself in the Human Rights Act, and anyway we do not overrule Parliament. It can ignore our declarations of incompatibility just as it can reverse or vary the effect of any judicial decision we make. A.M. the Home Secretary had a ringing dissent from Lord Hoffman on the issue of whether there was a public emergency. After quoting John Milton, he said that the real threat to the life of the nation comes not from terrorism, but from laws such as these. Like Lord Atkin in Liversidge, Lord Hoffman reminds us of the truth of a statement by an American judge I've already referred to, Justice Cardozo, that comparatively speaking, at least, the dissenter is irresponsible. The spokesman of the court is cautious, fearful of the vivid word, the heightened phrase. Not so, however, the dissenter. He is the gladiator, making a last stand against the lions. The poor man must be forgiven freedom of expression, tinged at rare moments with a touch of bitterness. And indeed, the dissenting judgment can be said to be the judicial embodiment of the fundamental right to freedom of expression. Now, my freedom of expression is very much at the risk of wrongly interfering with your freedom of movement and freedom of association. So I must move on to some very brief concluding comments. It would be nice, if a little showy, if I could end by identifying some unifying link between the 15 cases. However, the fact that I cannot do so is consistent with the fact that the almost infinite variety of human experience is faithfully reflected, as it should be, in the courts. Lawyers, like most professionals and academics, are ultimately concerned with looking for patterns with a view to analysing the past and the present, or predicting the future. But the truth is that the patterns are seldom there, or if they're there, we seldom find them. The best we judges can normally hope for is to build up and draw on our experiences on a practical, pragmatic basis, which is as principled as the vagaries of humanity allows. After all, as another American judge, Oliver Wendell Holmes, said, the life of the law is experience. And as the 15 cases show, the experience of judges and all those involved in the law is rich and varied. That richness and variety is attributable to a number of groups, and prominent among them are the law reporters. So I end as I began, by thanking and congratulating the ICLR for 150 years of consistent, faithful and intelligent law reporting, and by wishing them well for the next 150 years. Thank you very much.